Welcome to the Deep Dive, your shortcut to being well-informed, where we take complex information and distill it into clear, compelling insights. Today, we're embarking on a really crucial journey, a deep dive into the very heart of India's new criminal justice framework, the Bhartiya Nyaya Sanhita 2023. BNS 2023 for short. And look, this isn't just an update to some dusty legal document. It's the fundamental bedrock for how justice will be delivered, how crimes are defined, and ultimately how individuals like you are protected across India. Our mission today, it's to unpack some critical sections from Chapter 6 of offenses affecting the human body, and maybe glimpse into Chapter 7 too, which deals with offenses against the state. We're going to explore, well, everything, from the basic definitions of homicide right through to brand new provisions tackling things like organized crime, terrorism, and the absolute scourge of human trafficking. Now, for a learner like you, navigating such a huge legal text, it can seem daunting, right? But don't worry, we're here as your guides. We'll point out the most important bits, the surprising facts, and the practical implications that really matter. And here's where it gets really interesting. The BNS 2023, it's replacing the old colonial-era Indian Penal Code of 1860. That's a monumental legislative overhaul. Now, many concepts might seem familiar, sure, but there are crucial refinements, modernizations, and, importantly, entirely new offenses designed to meet the challenges of today's India.
Indeed. And this deep dive, it offers a really unique opportunity. We get to understand not just what the new law states, but also the underlying philosophy, the societal imperatives that are driving these profound changes. We'll be dissecting the precise legal language, exploring its nuances, and connecting it all to the broader jurisprudential landscape. We can draw upon decades of legal interpretation under the old IPC where similar provisions existed. What's particularly fascinating here is how the Sanhita really tries to clarify complex concepts. It introduces new categories of crime, things we face today, and in many cases it enhances protection for victims, while, crucially, ensuring proportionality in punishment. Our journey today will illuminate how this new code addresses fundamental questions of intent, causation, culpability, and that really delicate balance between individual liberty and the authority of the state. So, yeah, let's unpack this intricate tapestry of law.
All right, let's dive right in. We should start at the very beginning of offenses against the person with Section 100, culpable homicide. You mentioned it lays the groundwork. So this is like the foundational category, the big umbrella for all blameworthy killings.
Precisely. Think of it as the genus. It's how the law first distinguishes an unlawful death from, say, an accident or maybe a justified act like self-defense. At its heart, it's all about causing death with a specified criminal intent or knowledge.
Okay, intent or knowledge. The mens rea you mentioned, the guilty mind.
Exactly. Section 100 lays out three crucial mental states. First, if you cause death with the direct intention of causing death, that's pretty straightforward. You meant to kill. Second, if you intend to cause such a bodily injury as is likely to cause death. Here, the immediate intent is for the injury, but you know or should know that death is a highly probable outcome. And third, if you act with the knowledge that he is likely by such act to cause death. Now, in this last one, you might not specifically intend death, but you are acutely aware that your actions carry a very high probability of causing it. This spectrum, it allows the law to capture various degrees of blameworthiness.
That distinction between intention and knowledge, it seems really critical, doesn't it?
Absolutely critical. Intent implies a direct purpose, your aim. Knowledge means you're aware of the high likelihood of the consequence, even if it's not your primary goal. This nuance ensures a fair assessment of culpability. Take one of the illustrations in this section, for example. A knows Z is behind a bush, but B doesn't. A tricks B into firing at the bush, and B kills Z.
Ah, okay.
Here, B might be innocent if they were truly unaware. But A, who had the requisite knowledge or intent, has committed culpable homicide. The law ensures accountability, even when the immediate actor isn't the one with the guilty mind. B becomes, in effect, an unwitting instrument of A's criminal purpose.
That makes perfect sense. The guilty mind is paramount. And the BNS, like the IPC before it, includes some really important explanations for what causing death actually means in legal terms, right?
That's right. Explanation 1, for instance, clarifies that if you accelerate the death of someone who's already suffering from a disorder or disease, you're still considered to have caused that death legally.
So you can't argue, oh, they were going to die soon anyway.
No. The accused act is still considered causative. It addresses the but-for test. But for your action, the death wouldn't have occurred when it did. Similarly, explanation 2 reinforces that death caused by a bodily injury is attributed to the perpetrator, even if proper medical treatment could have prevented it. Generally speaking, Negligent medical treatment later on doesn't break that chain of causation if the original injury was the operative cause. This prevents offenders from escaping liability due to, subsequent events. The focus stays firmly on the initial act.
So no easy loopholes for a perpetrator based on what happens afterwards. And the law even clarifies the very beginning of legal human life for homicide purposes.
Yes, explanation 3 is quite precise. It states that causing the death of a child in the mother's womb is not homicide. But, and this is key, if any part of a living child has been brought forth, even if it hasn't breathed yet or isn't completely born, causing its death may amount to culpable homicide.
Okay.
That's where the law carefully delimits the start of independent human life for these purposes. It focuses on concepts like viability and independent existence. It's a foundational principle. And prior case law, like Anavi State of Rajasthan, helped clarify how courts distinguish these mental states.
Okay, so Section 100 sets the stage. The basic blameworthy killing. But what elevates culpable homicide to the gravest level, what we commonly call murder, that takes us to Section 101.
Exactly. Section 101 is where the culpability significantly increases, attracting the most severe penalties. It takes that basic culpable homicide and adds layers of either a more heinous intent or extreme recklessness.
So how does it define murder? What are those added layers?
Section 101 defines murder through 4 distinct clauses. Each reflects a heightened degree of blameworthiness. Clause A is the clearest, an intention of causing death, a direct purpose to kill, highest culpability. Clause B introduces a more subjective element. It's the intention of causing such bodily injury as the offender knows to be likely to cause the death of that specific person.
Ah, so it's about what the offender specifically knew about the victim's vulnerability.
Precisely. The offender's specific knowledge of the victim's peculiar susceptibility is key. For instance, knowing someone has a weak heart and intentionally causing them extreme shock.
Okay, that's very personalized. Then there's Clause C, which you said feels different.
It is. Clause C shifts to an objective assessment of the injury itself. It's the intention to cause bodily injury sufficient in the ordinary course of nature to cause death. Here, the focus isn't on the offender's specific knowledge of the victim, but on the nature of the injury. If an ordinary average person would likely die from such an injury like, say, a deep stab wound to a vital organ, then it's murder, regardless of whether the offender knew the victim was particularly frail or strong.
So, objective standard for the injury's lethality. And the last one, Clause
D. Clause D covers incredibly dangerous acts performed with reckless disregard. It's an act done with the knowledge that it is so imminently dangerous that it must, in all probability, cause death, and committed without any excuse for incurring that risk. This captures extreme recklessness, sometimes called a depraved indifference to human life. Think of someone firing a gun randomly into a dense crowd. They might not intend to kill any specific person, but they know death is highly probable. That's murder under this clause.
Okay, so those 4 clauses define when culpable homicide becomes murder. But Section 101 also provides 5 exceptions, right? Situations where even if the act technically fits the murder definition, it gets mitigated back down to culpable homicide, not amounting to murder.
That's correct. These exceptions acknowledge circumstances that reduce the offender's moral culpability. Exception 1, grave and sudden provocation, is perhaps the most well-known.
Right. The heat-of-the-moment defense.
In a way, yes. It acknowledges human frailty. If someone deprived of self-control by immediate severe provocation causes the death of the person who provoked them, or even another person by mistake, the charge is reduced from murder. But there are very strict conditions, the provisos. The provocation can't be sought by the offender as an excuse. It can't be caused by a public servant acting lawfully. And it can't be caused by someone lawfully exercising their right of private defense.
Okay, so you can't provoke someone just to get an excuse to harm them.
Exactly. And the concepts of a reasonable person standard and the lack of a cooling-off period are vital. The act must be impulsive, immediate, not premeditated after time to calm down. The landmark case, K.M. Nanavati v. State of Maharashtra, famously explored these nuances, even though its facts were quite unique.
So passion has to be immediate and overwhelming. What about Exception 2, exceeding the right of private defense?
This strikes a balance between self-protection and proportionality. If you're genuinely acting in private defense, but you exceed the legal limits of force allowed, without premeditation and without intending to cause more harm than necessary, and death results, it's culpable homicide, not murder. It recognizes the stress and urgency of such situations.
Makes sense. And Exception 4, sudden fight.
Similar logic. This applies when death is caused in an unpremeditated sudden fight, arising in the heat of passion upon a sudden quarrel. Crucially, It must be without the offender having taken undue advantage or acted in a cruel or unusual manner. The law emphasizes the lack of planning and a degree of, well, fairness in the fight, even if it turns lethal. It says it's immaterial which party offered the provocation or committed the first assault.
Okay, and the final exception, exception 5, consent. This sounds tricky.
It is, and it applies in very limited circumstances. If the victim, being over 18 years of age, suffers death or takes the risk of death with their own consent. Think potentially of situations like passive euthanasia, which has strict judicial guidelines in India, or perhaps historical practices like sati, though illegal now, if genuine free consent was ever truly present. It requires a clear, informed adult decision by the victim to accept that risk.
So a very narrow application. Ultimately, distinguishing murder from culpable homicide seems key.
Absolutely. Murder is culpable homicide, but not all culpable homicide is murder. These clauses, or exceptions, are the legal tools for making that critical distinction based on the degree of blameworthiness.
Okay, that's a lot of detail differentiating unlawful killings. Now, what if the murderous intent is aimed at person A, but tragically person B becomes the victim? Section 102 deals with this, right? Culpable homicide by causing death of unintended person, often called transferred malice.
That's the one. Section 102 addresses situations where, essentially, the offender's aim is poor or circumstances lead to an unintended victim. The core concept is straightforward. If you act with the intent or knowledge for culpable homicide towards victim A, but you accidentally kill victim B, whose death you neither intended nor knew was likely,
Then what happens?
then your liability for killing victim B is assessed exactly as if victim A had been killed.
So the criminal quality of the act, whether it's murder or culpable homicide not amounting to murder, remains the same as it would have been for the intended victim.
Exactly. The law effectively transfers your criminal intent, your malice, from your intended target to the actual victim. The objective is clear: to prevent offenders from escaping the full measure of their culpability simply because their aim was off or luck intervened.
So the accidental identity of the victim doesn't lessen the original criminal intent.
Precisely. The doctrine of transferred malice ensures that. If you shoot at someone intending murder, but you miss and kill an innocent bystander, you're still liable for murder. It's a powerful principle. Case law under the old IPC, like Shankar Narayan Padolkar v. State of Maharashtra, showed this principle in action.
It's a strong deterrent, certainly. Okay, so with the definitions of culpable homicide and murder established, let's move on to the consequences. What are the punishments? Section 103 outlines the punishments for murder. Subsection 1 sets the baseline, right? Death or imprisonment for life plus a fine.
Correct. That's the standard penalty, reflecting the utmost gravity of the offense.
But subsection 2 introduces something really significant. It deals with aggravated murder by a group often called hate crime or mob lynching. This feels like a direct legislative response to a serious societal issue.
It is. This is a major legislative development reflecting a shift in societal values and concerns in India. Subsection 2 states that if 5 or more persons acting in concert commit murder, and crucially, they do it on grounds of race, caste or community, sex, place of birth, language, personal belief, or any other similar ground.
Then what?
Then each member of that group faces the highest penalties: death or life imprisonment and a fine. This provision directly codifies enhanced punishment for prejudice-motivated group violence.
Then that phrase, any other similar ground, seems important. It gives it breadth.
Yes, it's crucial. It allows courts to interpret the provision broadly, potentially covering various forms of discriminatory motives beyond those explicitly listed. It functions effectively as direct hate crime legislation within the main penal code.
That sends a very strong message against mob violence and bigotry.
It does. It recognizes that such crimes don't just harm the individual victim. They undermine social harmony. They attack the very fabric of society. The severity underscores the sanctity of life, serving both retributive and deterrent purposes.
And the death penalty here, it would still be subject to the rarest of rare doctrine.
Oh, absolutely. The principles from Bakhan Singh v. State of Punjab would still apply. Courts would need to carefully weigh aggravating and mitigating circumstances before imposing the death penalty. And establishing that the group acted in concert would be key, likely drawing on principles of common intention, similar to Section 3.5 of the BNS, and perhaps jurisprudence from cases dealing with lynching, like Tehseen S. Poonawalla v. Union of India.
Okay. Now, what about the specific case of murder committed by someone already serving a life sentence? Section 104 seems to address this with even greater deterrence.
Yes, Section 104 is an exceptionally stringent provision. It states that if a person already undergoing a sentence of imprisonment for life commits murder, they shall be punished with either death or imprisonment for life. But here's the critical part,
Oh.
which shall mean imprisonment for the remainder of that person's natural life.
Wow. So life imprisonment in this specific context isn't the standard life sentence, which might have possibilities for remission or early release. It means literally for their entire remaining natural life. That's profound.
Precisely. It explicitly removes or severely curtails remission possibilities for this category of offender. It's a direct response to concerns about extreme recidivism and demonstrates the highest level of culpability. It's designed to deter further extreme criminality from individuals who've already received the maximum sentence for a previous crime and then commit murder again.
And this avoids the constitutional issues the old law had.
Correct. The old IPC Section 303, which mandated the death penalty for life convicts committing murder, was struck down by the Supreme Court in Mischief v. State of Punjab. Why? Because it removed judicial discretion entirely, violating fundamental rights. BNS Section 104 cleverly addresses this. It offers the judge discretion between death and the specific form of natural life imprisonment. So it's constitutionally sound while still being incredibly severe.
A very careful legislative balancing act. Now, for the unlawful killings that don't reach the level of murder, Section 105 outlines the punishment for culpable homicide, not amounting to murder.
Yes, and this section provides a graded punishment, reflecting the law's nuanced approach to culpability based on the specific mens rea. It essentially has two limbs. For acts done with a higher degree of culpability, that is, with the intention to cause death or the intention to cause an injury likely to cause death, the punishment is life imprisonment, or imprisonment for 5 to 10 years, plus a fine. But for acts done with a lower degree of culpability, meaning with the knowledge that the act is likely to cause death, but without those specific intentions, the punishment is lower, up to 10 years imprisonment, plus a fine.
So it mirrors the distinction we saw in the definition, matching the punishment directly to the level of intent or knowledge. It ensures proportionality.
Exactly. This distinction is critical for sentencing, reflecting different levels of moral blameworthiness. It aligns with the structure of the old IPC, Section 304, which had Part 1 and Part 2 based on this very distinction.
Okay. Moving beyond killings that involve intent or high probability, what about deaths caused by, well, just carelessness or negligence? Section 106 deals with causing death by negligence. This penalizes deaths resulting from rash or negligent acts that fall short of the intent or knowledge needed for culpable homicide. The general punishment is up to 5 years imprisonment and a fine. But there are a couple of really interesting specific provisions here, aren't there?
Yes, these distinctions are quite important. For general negligence, we're talking about criminal negligence. This requires a higher standard than mere carelessness in civil law. It needs to be gross negligence, a culpable disregard for the life and safety of others. Now, the BNS notably includes a specific lower maximum punishment for registered medical practitioners causing death by a rash or negligent act during a medical procedure. Here, the maximum is up to 2 years imprisonment.
Why the lower sentence for doctors?
It's a balance. It aims to ensure accountability, but also protect medical professionals from frivolous or overly harsh prosecution, acknowledging the inherent risks involved in medical practice. This reflects the principles laid down in prior jurisprudence, like the Jacob Matthew v. State of Punjab case, which emphasized that only gross negligence, not a simple error of judgment, should attract criminal liability for doctors.
That seems like a practical distinction. And the other specific provision, the one about hit-and-run driving cases, that seemed to have much higher penalties.
Yes, that's the other significant part of Section 106. It specifically addresses causing death by rash or negligent driving, where the act doesn't amount to culpable homicide, and the driver then escapes without reporting the incident to police or a magistrate soon after.
And the punishment.
It's substantially higher, up to 10 years imprisonment and a fine. Fleeing the scene is treated as a serious aggravating factor here. It imposes a greater duty of care and responsibility on drivers. This directly addresses a major societal concern and public outcry over hit-and-run incidents. It's worth noting, though, as per the sources, that this specific subsection, 106.2, has a deferred implementation date.
Okay, a strong message there, too. Now, shifting from accidental deaths to the tragedy of suicide and those who might facilitate it, Section 107 deals with abetment of suicide of vulnerable persons like children or someone of unsound mind.
This section reflects the extreme gravity the law attaches to exploiting a vulnerable individual's diminished capacity to induce them toward suicide. The penalties are very high: death or life imprisonment or imprisonment up to 10 years plus a fine.
Wow, even the death penalty is possible.
Yes, the potential penalties underscore society's strongest condemnation for such exploitation. The law essentially presumes these vulnerable individuals lack the full capacity for rational decision-making about ending their lives, making anyone who abets their suicide far more culpable. The definition of abetment itself would likely follow prior jurisprudence under IPC Section 305, requiring proof of active instigation, conspiracy, or intentional aid with a clear causal link to the suicide.
And what about abetting the suicide of a mentally capable adult? That falls under Section 108, abetment of suicide general.
Here, the punishment is less severe, though still significant, up to 10 years imprisonment and a fine. A crucial point for this offense is that the suicide must actually occur. This differs from abetment of many other crimes, where the principal offense does need to be completed for the abettor to be liable.
And the standard for proving abetment here?
Judicial interpretation under the old IPC Section 306, looking at cases like Sanju at Sanjay Sengar v. State of MP and M. Mohan v. State, has been quite strict. It requires proof of a clear mens rea to instigate the deceased to commit suicide and approximate causal link. Just using harsh words in anger or giving general advice might not be enough. There must be a clear intention to push the person towards suicide.
So the law differentiates quite strongly based on the victim's capacity and vulnerability. Okay, now let's explore acts that fall short of actually causing death but are carried out with lethal intent. Attempts. Section 109 deals with attempt to murder. This penalizes taking a substantial step towards committing murder, recognizing the danger and culpability of that murderous intent, even if death doesn't result.
Exactly. It's about penalizing the committed crime, the crime that's begun but not completed. If no hurt is caused during the attempt, the punishment is up to 10 years imprisonment and a fine. But if hurt is caused, the punishment could be life imprisonment or the general punishment.
And there's an aggravated punishment for life convicts again.
Yes, mirroring the structure for actual murder. If someone already serving a life sentence attempts murder and causes hurt in that attempt, the punishment is either death or a life imprisonment, meaning the remainder of their natural life. This reinforces the principle of extreme incorrigibility.
The section also clarifies the line between preparation and attempt, right?
Yes, the illustrations are helpful here. Buying a gun and loading it with intent to murder is cited as preparation, not yet an offense under this section. But firing that loaded gun at the intended victim, even if it misses, that's a clear attempt. Similarly, buying poison is preparation. Placing the poisoned food on the victim's table is the attempt. The act must be sufficiently proximate to the actual commission of the crime, not just remote preparation. Prior cases like State of Maharashtra v. Balram Bamba Patil helped establish how murderous intent in an attempt could be inferred from factors like the weapon used, the part of the body targeted, and the force applied.
So it's about crossing that threshold from merely thinking or planning to actually taking that substantial step towards the crime. And if the intent isn't for murder, but for the lesser offense of culpable homicide, that's Section 110, attempt to commit culpable homicide.
Correct. This section penalizes acts done with the intent or knowledge required for culpable homicide, not amounting to murder. The punishment is naturally less severe than for attempted murder. Up to 3 years imprisonment if no hurt is caused, and up to 7 years if hurt is caused, plus potential fines.
And the illustration links it to provocation.
Yes, the illustration given is someone firing a pistol at another on grave and sudden provocation. This clearly connects the attempted act to one of the mitigating circumstances, provocation, that would reduce murder to culpable homicide, thus making the attempt fall under this section rather than attempted murder. Discerning the precise mens rea intent for murder versus intent knowledge for culpable homicide is often the key difference, a task courts frequently tackled under the old IPC Section 308.
Okay, we've covered a lot on individual acts against the person, but the BNS also introduces major new categories tackling organized criminal enterprises and terrorism. This seems like a significant shift, bringing things previously under special acts into the main code. Let's start with Section 111, organized crime. This feels like a really big step in how India legally defines and combats sophisticated criminal networks.
It absolutely is a groundbreaking integration into the primary penal law. Organized crime is specifically defined here. It focuses on continuing unlawful activity carried out by an organized crime syndicate.
What do those terms mean legally here?
An organized crime syndicate is defined as a group of 2 or more persons acting together, like a gang, And continuing unlawful activity, this is critical means activity involving cognizable offenses punishable with 3 or more years imprisonment, where multiple charge sheets have been filed against members of the syndicate in the preceding 10 years, and a court has taken cognizance of those offenses.
So it's not just one crime. It requires a proven pattern of serious criminal activity by this established group or syndicate, often involving violence, intimidation, or coercion for material benefit like money or property.
Precisely. It targets the enterprise criminality itself, the ongoing nature of the criminal organization, rather than just isolated offenses. It covers a wide range of underlying crimes: kidnapping, extortion, contract killing, land grabbing, financial scams, cybercrime, trafficking, running prostitution rackets, dealing in arms or drugs, even counterfeiting currency or illicit betting.
And the punishments reflect this focus on organized networks.
Immensely so. If death results from an act of organized crime, the punishment is death or life imprisonment, plus a minimum fine of 10 lakh. If death doesn't result, it's still incredibly severe. A minimum of 5 years rigorous imprisonment, which can extend up to life, plus a minimum fine of 5 lakh. What's more, the section casts a very wide net. It punishes not just committing the crime, but also abetment, attempt, conspiracy, facilitating, harboring members, possessing property derived from organized crime. All carry severe mandatory minimum sentences and high fines. Subsection 7 even hints at a potential reverse burden of proof regarding unaccounted property held on behalf of syndicate members, a powerful tool often found in special laws like MCOCA, now brought into the General Code.
That's a massive legislative hammer against high-level criminal enterprises. But what about the smaller, maybe less sophisticated, but still structured criminal groups causing problems at a local level? Section 112 introduces petty organized crime. This feels genuinely innovative.
It is. This is a novel and, I think, very insightful provision designed to bridge a crucial gap in the law. It targets the organized commission of less grave, often street-level crimes carried out by groups or gangs. Think about things that plague communities but might not meet the very high threshold of Section 111.
Like what kind of activities?
The section lists examples. Theft, and importantly, theft here is broadened significantly to include trick theft, pickpocketing, vehicle theft, ATM theft, cargo theft, etc. Also snatching, cheating, unauthorized selling of tickets, like for events or travel, organized gambling, selling examination papers.
So persistent pickpocketing rings or groups systematically involved in exam paper leaks or maybe organized shoplifting gangs, these could fall under petty organized crime.
Exactly. The key element is the group or gang involvement, indicating an organized structure, even if for lower-level offenses. It aims to tackle that persistent, syndicated criminality that erodes public safety and trust, but might have fallen between the cracks before. The punishment reflects this middle ground, minimum 1 year, up to 7 years imprisonment, plus a fine.
The phrase, any other similar criminal act, is also included. That gives flexibility.
It does. It provides flexibility for law enforcement and courts, but its judicial interpretation will be crucial to define the precise scope and prevent misuse. Overall, it's a clear legislative attempt to crack down on that lower tier of organized crime.
Okay, from organized crime, large and small, we move to acts striking at national security itself. Section 113, Terrorist Act, another major integration of special law concepts into the BNS.
Yes, this section marks a very significant integration of anti-terror provisions into the General Penal Code. It defines a terrorist act broadly. It requires an act done with a specific intent.
What kind of intent?
The intent must be to threaten or likely to threaten the unity, integrity, sovereignty, security, or economic security of India, or the intent must be to strike terror, or likely to strike terror in the people, or any section of the people in India, or any foreign country.
And how is this intent carried out? What are the acts?
The act itself involves using specific means like bombs, dynamite, hazardous substances, lethal weapons, firearms, or other substances capable of causing death, injury, property damage, disruption of essential supplies, damage to critical infrastructure or defense assets, or even producing counterfeit currency. It also includes acts aimed at overawing public functionaries by criminal force, or coercing the government or any person to do or abstain from doing any act by detaining or kidnapping them.
That's a very comprehensive definition, covering both the intent and the wide range of potential actions.
It is, reflecting the multifaceted nature of terrorism today. The punishments are, as expected, extremely severe. If death results from a terrorist act, the penalty is death or life imprisonment, plus a fine. If death doesn't result, it's still a minimum of 5 years rigorous imprisonment, extending up to life plus a fine. And similar to organized crime, Section 113 also penalizes a wide range of ancillary activities: conspiracy, attempt, abetment, facilitation, organizing terrorist camps, recruitment, membership in a terrorist organization, harboring terrorists, and possessing proceeds of terrorism. All these carry very severe penalties.
There's also a procedural point about deciding which law applies.
Yes. Crucially, the section includes an explanation stating that an officer, not below the rank of superintendent of police, must decide whether to register the case under this BNS section 113 or under the existing special anti-terror law, the Unlawful Activities Prevention Act, 1967 UAPA. This acknowledges the overlap and provides the directive to avoid conflict between the general code and the special legislation.
So it provides a robust framework within the BNS while recognizing the continued existence of UAPA.
Exactly. And courts, when interpreting anti-terror laws, have consistently emphasized the need to prove that specific terrorist intent, distinguishing these acts from ordinary serious crimes, as seen in cases like People's Union for Civil Liberties v. Union of India. This BNS section operates within that understanding and, of course, under the umbrella of fundamental constitutional safeguards.
Okay. Having looked at these major new categories and crimes against the state, let's return to the core offenses involving direct harm to the individual body: hurt and grievous hurt. Let's start right back at the basics again. Section 114 defines hurt. Simple enough.
Conceptually, yes. Hurt is defined as causing bodily pain, disease, or infirmity to any person. It's the most basic form of physical injury recognized by the law.
And infirmity is quite broad.
Yes, it covers any unhealthy state of the body, even temporary loss of function or consciousness. Even minor physical pain qualifies as hurt. And interestingly, communicating a disease can also constitute hurt under this definition.
Okay. And if that hurt is caused voluntarily, that's Section 115.
Correct. Voluntarily causing hurt simply means doing an act with the intention of causing hurt, or with the knowledge that you're likely to cause hurt, and you do, in fact, cause hurt. This requires the mens rea intent or knowledge. Accidental hurt without this mental element isn't covered here.
And the punishment for simple voluntary hurt?
It's relatively minor, up to 1 year imprisonment, or a fine up to $10,000, or both. However, this section explicitly notes an exception for cases involving grave and sudden provocation. Those are dealt with under Section 122, which has much lower penalties.
Right, the provocation mitigation again. Okay, from simple hurt, we move to injuries of a much graver nature. Section 116 details grievous hurt. This isn't just any injury, it has to fit into specific categories, right?
That's exactly right. The law provides an exhaustive list of 8 categories that constitute grievous hurt. If an injury doesn't fall into one of these 8, it is legally considered simple hurt, no matter how painful it might seem subjectively.
What are some of these categories?
They include severe physical damage like emasculation, permanent loss of sight in either eye, permanent loss of hearing in either ear, loss of any member like an arm or leg or joint, destruction or permanent impairment of the power of any member or joint, permanent disfiguration of the head or face, or a fracture or dislocation of a bone or a tooth.
That covers very specific, serious, permanent damage. What's the last category, the catch-all?
That's clause H, and it's critical. It designates as grievous hurt any hurt which endangers life, or R which causes the sufferer to be, during the space of 15 days, in severe bodily pain, or unable to follow his ordinary pursuits.
Ah, the 15 days threshold. So even if it's not one of the specific permanent injuries, if it's life-threatening or causes severe pain or incapacitation for at least 15 days, it qualifies as grievous.
Precisely. Medical evidence becomes absolutely paramount for proving these categories, especially clause H and things like endangers life. Courts have interpreted endangers life to mean an injury intrinsically dangerous in itself, not just one that might become dangerous due to complications if left untreated. This section is vital for classifying injury severity and guiding appropriate punishment.
And when this grievous hurt is caused voluntarily, Section 117 lays out the penalties. What's required here?
Section 117 requires a dual element. The offender must voluntarily cause hurt, intending or knowing themselves likely to cause grievous hurt. And the hurt actually caused must be grievous hurt. It's not enough to intend simple hurt and accidentally cause grievous hurt. The mens rea must relate to the grievous nature of the intended or likely harm.
Okay, so the intent matches the severe outcome. What's the general punishment?
The general punishment is imprisonment up to 7 years and a fine. Again, this excludes cases of provocation which fall under Section 122.
But there are aggravated circumstances here too, right? Like for permanent disability.
Yes, significantly aggravated. If the voluntarily caused grievous hurt results in permanent disability or leaves the victim in a persistent vegetative state, the punishment is rigorous imprisonment for not less than 10 years. which may extend to imprisonment for life, specifically defined here as meaning imprisonment for the remainder of that person's natural life.
That natural life sentence, again, reflecting the absolutely catastrophic and lasting impact of such injuries.
Exactly. And mirroring the structure we saw from murder and organized crime, Section 117.4 introduces an aggravated punishment for group attacks, causing grievous hurt on discriminatory grounds. If a group of 5 or more, acting in concert, causes grievous hurt based on race, caste, community, sex, etc., each member is liable for imprisonment of up to 7 years and a fine.
So the hate crime principle extends beyond murder to cover grievous hurt caused by mobs as well.
It does. It's a very important extension, broadening the legal condemnation of prejudice-motivated violence. It reinforces principles from the old IPC sections 322 and 325, where proving the specific intent or knowledge for grievous hurt inferred from things like the weapon used, the force, the target area was paramount.
Now, you mentioned weapons. The means by which hurt is inflicted also significantly impacts culpability, which leads us to Section 118. Voluntarily causing hurt or grievous hurt by dangerous weapons or means.
This section reflects the common sense idea that using inherently dangerous tools or substances makes the act more culpable and warrants higher punishment. The law provides a long, illustrative list of what constitutes dangerous weapons or means.
What does it include?
It includes instruments for shooting, stabbing, or cutting. Any instrument which, used as a weapon of offense, is likely to cause death. Fire or any heated substance, any poison or corrosive substance, any explosive substance, any substance deleterious to the human body to inhale, swallow, or receive into the blood, or even any animal.
So it's quite comprehensive.
Yes, and the key is that the nature of the weapon or means is the aggravating factor. Even an ordinary object like a heavy stone or a lathie could potentially qualify as a dangerous weapon, depending on how it's used in the specific context.
And the punishments are higher.
Significantly. For causing simple hurt by these dangerous means, the punishment is up to 3 years imprisonment, or a fine up to $20,000, or both. But for causing grievous hurt by these dangerous means, the penalty jumps dramatically. It can be life imprisonment or imprisonment for 1 to 10 years plus a fine. These higher penalties reflect the increased danger and culpability associated with using such means, building on the jurisprudence of the old IPC sections 324 and 326.
Okay. Moving on from the direct infliction of hurt. Let's look at acts of violence motivated by coercion or other unlawful purposes. Section 119 covers voluntarily causing hurt or grievous hurt to extort property or constrain someone to do an illegal act. Here, the purpose behind the violence is key, right?
Exactly. The specific unlawful purpose extortion of property, valuables, or security, or compelling the victim or someone they care about to do something illegal, or which facilitates an offense, transforms the basic offense of causing hurt into a much more serious one. It protects not just bodily integrity, but also free will from violent coercion.
And the penalties reflect this aggravated nature.
They do. If simple hurt is caused for this purpose, the punishment is up to 10 years imprisonment plus a fine. If grievous hurt is caused for this purpose, it can be life imprisonment or imprisonment up to 10 years plus a fine. Establishing that unlawful purpose and the link between the violence and that objective is crucial for prosecution, as was the case under the old IPC sections 327 and 329.
Now, a related but distinct form of coercion involves extracting information, often in custody. Section 120 focuses on voluntarily causing hurt or grievous hurt to extort confession or compel property restoration. This seems particularly relevant to preventing police brutality or abuse of authority.
It absolutely is. This is a critical section designed specifically to safeguard individuals from torture, particularly when used to extract confessions or information leading to the discovery of property. The illustrations provided in the BNS itself make this explicit. They mention a police officer torturing someone to confess or reveal stolen property, or a revenue officer torturing someone to compel payment of arrears.
So it's a direct legal tool against practices like third-degree methods or forced confessions.
Precisely. It directly underpins the fundamental right against self-incrimination guaranteed by Article 23 of the Constitution and upholds the principles of due process. Confessions must be voluntary. Landmark cases like DK Basu v. State of West Bengal lay down extensive guidelines against custodial torture, and this section provides the penal sanction to enforce those protections.
What are the punishments under Section 120?
If simple hurt is caused for these purposes, extorting confession, compelling restoration of property, the punishment is up to 7 years imprisonment plus a fine. If grievous hurt is caused for these specific purposes, it's up to 10 years imprisonment plus a fine.
Okay. What about violence directed specifically at those trying to uphold the law? Section 121 deals with voluntarily causing hurt or grievous hurt to deter a public servant from duty.
This section provides special protection to public servants, recognizing the need to uphold state authority and ensure officials can perform their duties without fear of violent reprisal. It covers causing hurt or grievous hurt to a public servant while they are discharging their duty, or with the intent to prevent or deter them from discharging their duty, or as a consequence of anything lawfully done by them in the discharge of their duty.
So it covers acts during duty, acts intended to deter future action, and acts in retaliation for past lawful actions?
Yes, it's quite comprehensive in protecting officials related to their lawful functions. For causing simple hurt under these circumstances, the punishment is up to 5 years imprisonment, or a fine, or both. For causing grievous hurt, there's a minimum sentence of 1 year, extending up to 10 years, plus a fine. Of course, it must be proven that the victim was a public servant acting lawfully within their official scope, aligning with the requirements of the old IPC sections 332 and 333.
And finally, for this group of offenses, the law again accounts for human frailty under provocation, Section 122. Voluntarily causing hurt or grievous hurt on provocation.
Yes, similar to how provocation mitigates murder to culpable homicide, it also mitigates the punishment for causing hurt or grievous hurt. If the act is committed as an immediate reaction to grave and sudden provocation, and the harm is directed at the person giving the provocation or someone else by mistake due to the provocation, the penalties are significantly reduced.
How much lower?
For simple hurt caused on provocation, it's only up to 1 month simple imprisonment, or a fine up to $5,000 or both. For grievous hurt caused on provocation, it's up to 5 years imprisonment, or a fine up to $10,000 or both. And importantly, the explanation links this directly to the same provisos as the provocation exception for murder, Section 101, Exception 1, meaning the provocation must not have been sought by the offender, must not have been given by a public servant acting lawfully, and must not have been given in the exercise of lawful private defense. Both the grave and sudden elements must be present, and the retaliation must be immediate, without a cooling-off period. It's a legal recognition of diminished self-control under extreme immediate stress, reflecting the principle seen in IPC sections 334 and 335.
Okay, now let's shift focus slightly to more insidious ways of causing harm using substances, and also general threats to public safety. Section 123 talks about causing hurt by means of poison, etc., with intent to commit an offense. This seems aimed at clandestine attacks.
Yes, this section penalizes the secret administration of harmful substances. It covers administering or causing someone to take any poison or any stupefying, intoxicating, or unwholesome drug or other thing with the intent to cause hurt, or with the intent to commit or facilitate the commission of an offense, or knowing it to be likely that hurt will be caused.
So it covers a broad range of substances and criminal intentions.
Exactly. The other thing phrasing gives it width. The intent could be simply to cause hurt, or it could be to incapacitate the victim to make them vulnerable for another crime, like robbery or sexual assault. The punishment reflects this danger, up to 10 years imprisonment plus a fine. This aligns with the purpose of the old IPC Section 328, requiring proof of the act, the nature of the substance, and the specific criminal intent or knowledge.
A particularly horrific type of attack involves corrosive substances. Section 124 specifically criminalizes voluntarily causing grievous hurt by use of acid, etc. This feels like a very direct legislative response to acid attacks.
It absolutely is. This is a strong, specific legislative response to a particularly vicious and disfiguring form of violence. It targets causing permanent or partial damage, deformity, burns, maiming, disfigurement, disability, or causing a persistent vegetative state, PVS, by throwing or administering acid or a similar corrosive substance with the intent or knowledge that such injury is likely.
And the punishment is severe.
Extremely severe. The minimum sentence is 10 years rigorous imprisonment, which can extend up to life imprisonment, and a fine. And the provisos regarding the fine are crucial here.
What do they say?
They explicitly state that the fine imposed must be just and reasonable to meet the victim's medical expenses and rehabilitation needs, and importantly, that the fine collected must be paid directly to the victim.
That victim-centric fine is a really vital modern feature, isn't it? Focusing on tangible support and restorative justice for the survivor.
Precisely. It's a significant step. The section also penalizes attempts to throw or administer acid with the intent to cause such grievous injuries, with a minimum sentence of 5 years, up to 7 years imprisonment, plus a fine. The definition of acid is broad, covering any substance with an acidic, corrosive, or burning nature capable of causing scars, disfigurement, or disability. And explanation 2 clarifies that the resulting permanent or partial damage, or PVS, need not be irreversible for the offense to be established. This strengthens the provision, reflecting the spirit of judicial directives in cases like Laxmi v. Union of India regarding acid sales regulation and victim compensation.
Okay. Beyond these targeted attacks with substances, how does the law handle general reckless behavior that endangers people? Section 125, act endangering life or personal safety of others.
This section penalizes acts done so rashly or negligently as to endanger human life or the personal safety of others, even if no actual harm occurs. It's an important principle. Creating a significant unjustifiable risk can itself be a criminal offense.
So the risk itself is punishable?
Yes. The base punishment for just endangering life or safety is up to 3 months imprisonment, or a small fine, or both. However, if the rash or negligent act does cause hurt, the punishment increases to up to 6 months imprisonment or a larger fine. And if it causes grievous hurt, the punishment goes up further to 3 years imprisonment or an even larger fine. This section promotes public safety by covering a wide variety of careless actions that might not fall under more specific offenses, like, say, extremely reckless driving that creates obvious danger but miraculously doesn't cause death or grievous hurt. It requires criminal rashness or negligence, a higher degree of culpability than mere civil negligence, distinguishing it as the old IPC sections 336, 337, and 338 did. All right. Now let's turn to offenses against personal liberty and the unlawful application of force. Sections 126 through 136. Section 126 defines wrongful restraint. This is about partially depriving someone of their freedom of movement. Exactly. It's defined as voluntarily obstructing any person so as to prevent them from proceeding in any direction in which that person has a right to proceed. It's about blocking a specific path or direction, not total confinement.
Like blocking someone on a public footpath.
Precisely. The exception is if you obstruct a private way over land or water in a good faith belief that you have a lawful right to do so. Otherwise, blocking someone's rightful path is wrongful restraint. It's a relatively minor offense, punishable with simple imprisonment up to 1 month or a small fine. It protects the basic liberty of movement, echoing IPC Section 339.
Okay, from partial restraint to total restriction of movement. Section 127, wrongful confinement.
This means wrongfully restraining a person in such a manner as to prevent them from proceeding beyond certain circumscribing limits. It's total deprivation of liberty within defined boundaries. Locking someone in a room or placing guards at all exits of a building to prevent someone leaving. Those are classic examples.
And the BNS has graded punishments here based on duration and circumstances.
Yes, quite meticulously. The basic punishment for wrongful confinement is up to 1 year imprisonment or a fine. But it escalates. If the confinement lasts for 3 or more days, it's up to 3 years. If it lasts for 10 or more days, it's up to 5 years imprisonment and a minimum fine. There are further aggravations, too. If the confinement is done knowing a writ for the person's liberation has been issued, defying a court order, there's an additional 2 years. If the confinement is done secretly, aiming to prevent discovery, there's an additional 3 years. And if the confinement is for the purpose of extorting property or compelling an illegal act, or for extorting a confession or information, the punishment is up to 3 years plus a fine.
Wow, a very layered approach to protecting liberty.
It is. It penalizes both the basic act and various aggravating circumstances, reflecting the seriousness of depriving someone of their freedom. It mirrors the structure of the old IPC sections 340 and 342, 348, emphasizing that the restraint must be total, and of course free and valid consent for the person confined would negate the offense.
Okay. Now, how does the law define the very essence of physical interaction that can become criminal? Section 128 defines force. This seems foundational.
It is foundational for understanding subsequent offenses like criminal force and assault. Section 128 defines using force very broadly. It means causing motion, change of motion, or cessation of motion to another person, or causing motion change or cessation of motion to any substance if that contact affects the other person's body or their sense of feeling.
So it's not just about hitting someone.
Not at all. It can be direct bodily power, like pushing someone. It can be disposing a substance in such a way that it causes motion affecting someone without any further act by the offender, like setting a stone rolling down a hill towards someone. Or it can be inducing an animal to move, change its motion, or cease motion towards someone. It includes indirect contact that affects sensation, like applying heat or cold. Any such physical effect qualifies. It captures the physical element, the actus reus, of what common law often calls battery.
Okay, that's force. When does this physical interaction become criminal force under Section 129?
Force becomes criminal force when it's used intentionally against a person, without their consent, and with an unlawful purpose.
What kind of unlawful purpose?
The purpose must be either to commit any offense or to cause, or knowing it likely to cause, injury, fear, or annoyance to the person to whom the force is used.
The illustrations here seem very broad, shaking a fist, setting a dog on someone.
Yes, the illustrations are quite telling. They range from acts that might seem minor, like shaking a fist with threatening intent, or pushing someone aside in the street, or pulling a woman's veil without consent, to more obviously harmful acts like throwing a stone or inciting a dog to attack. Even the slightest intentional, non-consensual touch, if done with an unlawful purpose, like causing annoyance, can technically qualify as criminal force. Injury here is defined broadly in the BNS to include harm to body, mind, reputation, or property. This section is the direct equivalent of common law battery.
Okay. And from criminal force, the actual application of force, we move to its apprehensive cousin, assault, Section 130.
Assault, under Section 130, doesn't require any physical contact at all. It's about creating an apprehension in the mind of another person that criminal force is about to be used against them.
So it's about the threat, the fear of imminent violence.
Exactly. The offense is making any gesture or any preparation, intending or knowing it, to be likely that such gesture or preparation will cause another person present to apprehend that the person making it is about to use criminal force against them. The explanation clarifies that mere words alone don't constitute assault, but the words used can give meaning to gestures or preparations. Shaking a fist at someone is assault. Doing so while saying, "I'll hit you," makes the intent even clearer. The key is the reasonable apprehension of imminent unlawful force in the mind of the person threatened. It's often seen as an attempted battery, protecting a person's right to feel secure from immediate physical attack. This aligns with the old IPC Section 351.
Okay, so we have force, criminal force, the act, and assault, the apprehension. What are the general punishments for assault or criminal force when there's no grave provocation involved? Section 131 covers this baseline.
Section 131 provides the general punishment for committing assault or using criminal force otherwise than on grave and sudden provocation. It sets the baseline penalty at imprisonment up to 3 months, or a fine up to $1,000, or both. It also includes explanations reiterating the situations where provocation will not mitigate the offense, basically mirroring the provisos from the murder exception. Provocation sought by the offender, provocation given by a public servant acting lawfully, or provocation given by someone exercising lawful private defense. It establishes the standard penalty for minor physical aggressions or threats, deterring everyday breaches of peace.
And predictably, there's an aggravated version for public servants again, Section 132. Assault or criminal force to deter a public servant from duty.
Yes, consistent with the protection offered against hurt and grievous hurt, this section provides enhanced punishment for assaulting or using criminal force against a public servant in the execution of their duty, or to deter them, or in reprisal. The punishment here is higher than for general assault. Imprisonment up to 2 years, or a fine, or both. It underscores the importance of respecting public authority and allowing officials to perform their duties, aligning with IPC Section 353.
What about acts of force intended specifically to degrade or humiliate? Section 133. Assault or criminal force with intent to dishonor person.
Here, the specific mens rea is the intent to dishonor the person assaulted, assuming there wasn't grave provocation. It's about protecting individual dignity and reputation from acts intended to cause shame or public humiliation. The punishment is imprisonment up to 2 years, or a fine, or both. Proving the dominant intent to dishonor, inferred from the nature of the act and circumstances, is key, as was the case under IPC Section 355.
Force is also often used in attempts to steal from someone directly. Section 134. Assault or criminal force in attempt to commit theft of property carried by a person.
This section specifically targets the use of assault or criminal force in an attempt to steal property that a person is wearing or carrying. Think of failed attempts at snatching a bag or pickpocketing where some force or threat was used against the person. The punishment is imprisonment up to 2 years, or a fine, or both. It addresses those confrontational theft attempts involving direct interaction with the victim, aligning with IPC Section 356.
Or force used in an attempt to wrongfully confine someone. Section 135. Assault or criminal force in attempt to wrongfully confine a person.
This criminalizes using assault or criminal force as part of an attempt to unlawfully confine someone. Even if the confinement itself is ultimately unsuccessful, the use of force or assault in that attempt is punishable. The penalty is imprisonment up to 1 year or our fine up to $5,000 or both. It penalizes those preparatory acts involving force aimed at unlawful detention, reflecting IPC Section 357.
And finally, returning one last time to provocation for these lesser offenses of force. Section 136, assault or criminal force on grave provocation.
Yes, mirroring the mitigation for hurt and grievous hurt. This section provides a much lower mitigated punishment if assault or criminal force is committed on grave and sudden provocation. The penalty is very lenient. Simple imprisonment up to 1 month, a fine up to $1,000 or both. The same limitations on what constitutes valid provocation, not sought, not by lawful acts, etc., apply here as in Section 131. It recognizes diminished self-control for these less serious acts committed in the heat of the moment, reflecting IPC Section 358.
Okay, we've covered force and restraint. Now let's move into offenses involving the movement and exploitation of persons. Kidnapping, abduction, and related crimes, starting with Section 137. Kidnapping.
Section 137 defines kidnapping and outlines 2 distinct kinds. The first is kidnapping from India, which means conveying any person beyond the limits of India without that person's consent or the consent of someone legally authorized to consent on their behalf. The second, and perhaps more commonly encountered, is kidnapping from lawful guardianship. This involves taking or enticing any child under 18, male or female, or any person of unsound mind out of the keeping of their lawful guardian without that guardian's consent.
So consent is paramount, either the person's own or their guardian's, if applicable, and lawful guardian is defined broadly.
Yes, the explanation clarifies it includes anyone lawfully entrusted with the care or custody of the minor or person of unsound mind. For minors, the terms takes or entices are important. Taking doesn't necessarily require force. Simply inducing the minor to accompany can be enough, as established in cases like S. Varadarajan v. State of Madras. Enticing involves some kind of lure or inducement.
Is there any exception?
There's a limited exception for someone who in good faith believes they are the father of an illegitimate child or believes they are entitled to lawful custody unless the taking or enticing is done for an immoral or unlawful purpose. This exception is narrow, emphasizing the child's welfare. The general punishment for kidnapping under this section is imprisonment up to 7 years, plus a fine.
Okay, that's kidnapping. Now, Section 138 defines abduction. You mentioned earlier this is different. It's not a standalone crime, but an ingredient.
Precisely. Abduction itself isn't punishable per se, but it's a crucial element in several aggravated offenses. Section 138 defines abduction as compelling a person by force or inducing them by any deceitful means to go from any place.
So the means are key. Force compulsion or deceit trickery.
Exactly. And unlike kidnapping from guardianship, the age or mental capacity of the victim isn't specified here, so adults can be abducted if forced or deceived. It's about causing movement through illicit means. Importantly, abduction is generally considered complete once the movement from one place to another occurs. It's not inherently a continuing offense like wrongful confinement might be. This distinction from kidnapping was also present in the old IPC Section 362.
Now, how do these acts combine with truly nefarious purposes, especially concerning children? Section 139 deals with kidnapping or maiming a child for purposes of begging. This sounds absolutely horrific.
It is one of the most brutal forms of child exploitation imaginable, and the law under BNS reflects that severity with extremely harsh penalties. Kidnapping or unlawfully obtaining custody of a child with the intention that the child will be employed or used for begging carries rigorous imprisonment for not less than 10 years, which may extend to life imprisonment, plus a fine.
And if the child is maimed?
If anyone maims a child, meaning causes permanent injury or disfigurement, specifically to make them an object of pity for begging, the punishment is even more severe. Rigorous imprisonment for not less than 20 years, which may extend to life imprisonment, defined here as imprisonment for the remainder of that person's natural life, plus a fine.
20 years minimum, potentially natural life. That's incredibly stringent, reflecting the sheer cruelty involved.
Absolutely. The law also includes a powerful tool for prosecution, a rebuttable presumption. If a person who isn't the lawful guardian employs or uses a child for begging, it's presumed they kidnapped or obtained custody for that purpose unless they can prove otherwise. This helps tackle organized child begging rackets. Begging itself is defined very broadly, including not just soliciting alms, but things like singing, dancing, fortune-telling, or exhibiting deformities or injuries for money or sympathy. This builds upon the framework of IPC Section 363A.
Kidnapping and abduction can, of course, be perpetrated for many other grave purposes. Section 140 covers kidnapping or abducting in order to murder or for ransom. among other things. This bundles several aggravated intents.
Yes, Section 140 outlines various aggravated forms, scaling the punishment according to the heinousness of the intended purpose. If the kidnapping or abduction is done in order that such person may be murdered or disposed of in a way that puts them in danger of being murdered, like the illustration of kidnapping for human sacrifice, the punishment is life imprisonment or rigorous imprisonment up to 10 years, plus a fine.
And the provision for ransom, that seems particularly relevant today.
Extremely relevant. Subsection 2 deals specifically with kidnapping or abducting or detaining someone and threatening to cause death or hurt in order to compel the government or any foreign state, international organization, or any other person to do or abstain from doing any act or to pay a ransom. This carries the most severe penalties under this section: death or life imprisonment, and a fine.
Death penalty is an option there, a very strong stance against kidnapping for ransom.
Indeed. The section also covers other grave intents with significant punishments: kidnapping or abducting for secret and wrongful confinement, up to 7 years, or kidnapping, abducting for the purpose of subjecting the person to grievous hurt, slavery, or the gratification of unnatural lust, up to 10 years. The specific intent behind the kidnapping or abduction determines the applicable subsection and punishment, reflecting the comprehensive approach seen in the old IPC sections 364, 364A, 365, and 367.
Okay. Our final set of sections we'll delve into today continues this focus on exploitation and includes some offenses that were previously in different parts of the IPC or required reference to special laws. Section 141 deals with the importation of a girl or boy from a foreign country, specifically targeting transnational trafficking of minors for sexual exploitation.
Yes, this section directly combats the cross-border trafficking of children and young persons into India for sexual purposes. It penalizes anyone who imports into India from any foreign country a girl under 21 years old or a boy under 18 years old with the intent that they may be, or knowing it to be likely that they will be, forced or seduced into illicit intercourse.
Illicit intercourse meaning outside lawful marriage, and different age thresholds for girls and boys.
Correct on both counts. The punishment is imprisonment up to 10 years, plus a fine. Proving the importation, the age of the victim, and the requisite mens rea, intent or knowledge regarding the intended sexual exploitation, is crucial. It reflects India's commitment under international conventions to combat transnational organized crime and protect vulnerable minors, carrying forward the essence of IPC Section 366B.
After the act of kidnapping or abduction itself, what about those who help afterwards by hiding the victim? Section 142 covers wrongfully concealing or keeping in confinement a kidnapped or abducted person.
This establishes clear accomplice liability for assisting after the fact. If you know that a person has been kidnapped or abducted, and you then wrongfully conceal or confine that person, you're punished in the same manner as if you yourself had kidnapped or abducted that person with the same intention, knowledge, or purpose for which you are concealing or detaining them.
So your punishment depends on your own state of mind regarding why you're hiding them, and is equivalent to the principal offense linked to that purpose.
Exactly. The accused's knowledge of the prior kidnapping or abduction is essential. The punishment is directly linked to the severity of the underlying crime, reflecting a shared criminal purpose or facilitation. This deters people from aiding kidnappers or abductors after the initial act, building on principles of accessory liability seen in IPC Section 368.
Now, for a really comprehensive look at human trafficking itself, Section 143, trafficking of person, the BNS seems to be tackling this global scourge head-on with a detailed provision.
It does. Section 143 provides a very comprehensive definition of trafficking, aligning closely with international standards like the UN Palermo Protocol. It covers the acts of recruiting, transporting, harboring, transferring, or receiving a person.
And for what purpose?
For the purpose of exploitation. And exploitation is defined inclusively to cover physical exploitation, sexual exploitation, slavery or practices similar to slavery, servitude, forced labor or services, beggary, or the forced removal of organs. And critically, this must be done using specific illicit means: threats, force, coercion, abduction, fraud, deception, abuse of power or position of vulnerability, or receiving payments or benefits to achieve the consent of a person having control over another person.
And the victim's consent, does that matter?
Crucially, Explanation 2 states, the consent of the victim is immaterial where any of those illicit means have been used. This is a cornerstone of modern anti-trafficking law. It recognizes that any consent obtained through coercion, deception, or abuse of vulnerability is not legally valid consent.
That's a vital clarification, addressing the power dynamics inherent in trafficking situations.
Absolutely. The punishments are extremely severe. and are graded based on the circumstances. General trafficking carries rigorous imprisonment of not less than 7 years, up to 10 years. If it involves trafficking multiple persons or trafficking a child, the minimum is 10 years, extending up to life. If multiple children are trafficked, the minimum is 14 years, up to life.
And for repeat offenders or officials involved?
For a repeat conviction involving trafficking a child, or if a public servant or police officer is convicted of trafficking, the punishment is imprisonment for life, defined as the remainder of that person's natural life, plus a fine. These stringent mandatory minimums and natural life sentences show an incredibly strong legislative intent to combat trafficking in all its forms, drawing on principles from IPC Section 370 and cases like Bakpen Bakalandalan v. Union of India.
Complementary to punishing the traffickers is punishing those who exploit the victims. Section 144, exploitation of a trafficked person. This targets the demand side, right?
Exactly. This is a crucial provision for attacking the demand that fuels sexual exploitation, particularly of trafficked individuals. It penalizes anyone who, knowingly or having reason to believe that a person, especially a child, has been trafficked, then engages that person for sexual exploitation in any form.
And the punishment differs for child victims versus adult victims.
Yes. If the victim engaged for sexual exploitation is a child known or reasonably believed to be trafficked, the punishment is rigorous imprisonment for not less than 5 years, up to 10 years, plus a fine. If the victim is an adult known or reasonably believed to be trafficked, the punishment is rigorous imprisonment for not less than 3 years, up to 7 years, plus a fine. The knowledge or reason to believe standard is key here, aiming to hold the consumers accountable.
Okay. And looking at the most extreme form of exploitation historically, Section 145 deals with habitual dealing in slaves.
This section unequivocally condemns and seeks to eradicate all forms of slavery, aligning with Article 23 of the Constitution. It criminalizes habitually importing, exporting, removing, buying, selling, trafficking, or dealing in any person as a slave. The term habitually is important. It requires proving a pattern of conduct, not just an isolated instance. Slave refers to a person over whom rights of ownership are exercised. The punishment is severe, life imprisonment, or imprisonment up to 10 years, and a fine. It carries forward the intent of IPC Section 371.
And finally, a broader category related to forced work. Section 146, unlawful compulsory labor.
This criminalizes unlawfully compelling any person to labor against their will. The compulsion must be unlawful meaning, not sanctioned by law, unlike, say, compulsory service for public purposes allowed under Article 23 of the Constitution. This compulsion can involve physical force, economic coercion, threats, or other means. The punishment is imprisonment up to 1 year, or a fine, or both. It protects individuals from forced labor, upholding their liberty and dignity, reflecting constitutional principles and jurisprudence, like the aged workers case, which interpreted forced labor broadly, even including work for less than minimum wage, if compulsion was present. It aligns with the old IPC Section 374.
We've covered an immense amount of ground, from the nuances of homicide to the complexities of organized crime, trafficking, and offenses against liberty and the body. While our deep dive focused on the detailed exposition up to Section 146 provided in our source material, it's clear the Bhartiya Nyaya Sanhita continues into Chapter 7 with crucial offenses against the state itself, things like waging war, sedition under a potentially new formulation, promoting enmity, and more, all aimed at protecting the nation's integrity and security. Okay, let's try and unpack this huge journey we've taken through these critical sections of the BNS 2023, from those really fundamental distinctions between culpable homicide and murder to the, profound implications of things like transferred malice and the very detailed graded punishments for different levels of intent or knowledge. This new legal framework, it's incredibly nuanced, isn't it?
It really is. The level of detail is striking.
And we've seen how the law has clearly tried to modernize to tackle really complex contemporary issues like organized crime, that very interesting new category of petty organized crime, and terrorist acts, bringing these grave offenses right into the main penal code. What really stood out to me personally were those specific provisions targeting hate-motivated group violence, both for murder and grievous hurt. Also, the very victim-centric approach in the acid attack section, with the fine going directly to the survivor. And of course, those enhanced penalties, often meaning natural life for life convicts who commit further heinous crimes, or for traffickers in certain situations.
Precisely. And if you connect all these threads, step back and look at the bigger picture, it becomes quite evident that the BNS 2023 isn't just, a simple reenactment of the old laws with new section numbers. It seems to be a genuine reflection of India's evolving societal values, its concerns, and a strategic, quite targeted response to modern criminal challenges. particularly in areas like organized crime, terrorism, human trafficking, and the exploitation of vulnerable persons. You see this emphasis throughout on clearer definitions, on those detailed explanations clarifying scope, and on the carefully graded punishments. It all seems aimed at contributing to a more robust, hopefully more responsive legal system. The consistent theme, really, across all these sections we've discussed, is this unwavering commitment to protecting fundamental values, human life, bodily integrity, personal liberty, and ultimately the security and integrity of the state itself. And this, I think, raises a really important question for you, the learner, to consider going forward. How do these significant legislative shifts, especially the introduction of totally new categories like petty organized crime, or the much stronger focus on discriminatory motives and hate crimes, how might these reshape the day-to-day role of law enforcement? And what impact could they have on community safety at the local level? Do they create clearer pathways to justice, or perhaps introduce new challenges in terms of implementation and interpretation?
That's a fantastic thought to ponder as this new code begins to be applied in practice. Its actual application, how the police investigate, how prosecutors argue, how judges interpret, that will undoubtedly shape India's legal landscape for generations to come. We certainly hope this deep dive has given you a clear, engaging, and, well, a well-informed perspective on these absolutely critical legal provisions. Thank you so much for joining us on this exploration of the Bhartiya Nyaya Sanhita. Until our next deep dive, keep learning, keep questioning, and keep being well informed.